Hello, good afternoon. My name is Lori Tripoli, and I am an HR consultant with Pinnacle Human Resources. Thank you for joining me for today's session on the New York Health and Essential Rights Act, otherwise known as the New York HERO Act. This new law was signed into effect May 5th of 2021. During today's session, I will take you through a brief overview of the new law as well as some of the amendments. And then we will focus on two parts of the law. Part one is the actual prevention plan, and then part two is the safety committee component. We'll also cover some frequently asked questions, and I will share with you the link to the Department of Labor, as well as two of the available documents that are out on the Department of Labor website that will be critical for you as you begin to put your plan together. Governor Cuomo signed the New York Health and Essential Rights Act, the New York HERO Act, into law on May 5th of 2021. This new act changes New York state labor laws and will impose substantial responsibilities on all private employers to provide and maintain safe workplaces for the ongoing COVID-19 pandemic and for all airborne infectious disease outbreaks in the future. Part one we're going to talk about is the Airborne Infectious Disease Exposure Prevention Plan. So you're required to develop a prevention plan if you are a private employer. And so there are some now dates that have been identified for you to begin working on, and you've got some deliverables. This new law and the prevention plan itself became effective July 6th. That is when the Department of Labor released the various models that you can use for developing a work plan. So that is when the clock started ticking. All plans must be adopted by August 5th. So you have 30 days to adopt a plan. Then you have an additional 30 days to then put the plan in place. So by September 6th, you will need to distribute a copy of the plan to your workforce. You'll need to incorporate the plan into your new hire communication. So each time you bring a new employee into the organization, they have to be made aware of your work plan. And then you need to include it as a part of your handbook, if that's applicable. As mentioned, the Department of Labor released their model notices on July 6th. There are 11 different industry-specific models to choose from, and there are some advantages for just using the Department of Labor work plan, and I will show you that later in the presentation. One of the amendments that was made is that the deadline for employers to adopt the Airborne Infectious Disease Exposure Prevention Plan is 30 days. So as I said, that clock started ticking from July 6th to August 5th. There is some discussion out there as to whether or not that will get moved out further. Okay, so more to come. We'll update our clients when we have that available information. Some of the more details about the prevention plan. Excuse me, the plan covers private sector employers along with their workers. So this means not just employees, it includes temporary workers, contractors, independent contractors, even seasonal workers. So workers is defined very broadly in this work plan and who it applies to. The work plan does exclude work sites that are not under the employer's control. So if you don't have full control of the facility, then that is deemed as an exclusion. So the amendment below goes on to mention that the work sites for which the Department of Labor must publish models and for which employers must adopt plans are now explicitly limited to those over which an employer has the ability to exercise control. So the amendment also clarified that covered work sites do not include telecommuting or telework sites over which the employer lacks the ability to exercise control or vehicles. However, if you are at a construction site and you have trailers as a part of your construction site, you have control over those trailers. Those do become applicable in terms of inclusion as a part of developing your work plan. The plan must be industry specific, as I mentioned, there are 11 different models to choose from. There is a construction model template available, so we'll take a look at that shortly. The plan must include mandates for health screening, face coverings, PPE, hygiene stations, regular cleaning and disinfecting, social distancing, engineering controls. Employers can either adopt one of the model standard exposure prevention plans applicable to their industry, so one of the ones that have already been created by the Department of Labor, and then you can simply add in your specific company information, and that will meet the standard. If you choose not to do that, then you can develop and establish an alternative prevention plan, and at a minimum must meet the basic plan that is available out on the website, and then certainly build from there. In developing your own plan, employer plans must entail meaningful participation of employees in the course of development or union agreement. So what this means is, if you use one of the available models that the Department of Labor has created, you do not need to involve employees in the participation of your work plan and the creation of that document. If you choose not to use one of the available models and create your own, you then need to include employees in the creation and the development of that work plan. Your plan will need to be customized to the who, what, and how specific to your organization. When you get into the plan itself, it outlines these questions for you, and you need to answer them as you move from one section to the next. Training is also required on the plan. So one of the amendments that was made, employers will also be required to distribute their adopted plans to newly hired employees at the time of hire, and to all employees within 15 days after reopening after a period of closure due to airborne infectious disease. So you're going to need to think about how to incorporate this into that new hire process. The plan must be posted and included in the employee handbook, and postings must be at all sites excluding vehicles. Only supervisors can be tasked with responsibility for compliance with the plan, and all supervisory personnel are considered the employer. So once your plan is developed, and as you are developing your plan, you will need to identify supervisors in your organization who will be responsible for compliance of the plan. And what that means is, these are going to be the individuals who are going to be responsible for keeping track of what is being communicated by the Department of Health, by the perhaps executive order or messages coming out from the governor, where there are hot spots, who's being required to put additional procedures in place based upon infections going up. And so these individuals are going to need to be those eyes and ears for your organization, for your site, as you go forward, and that will need to be defined in your work plan. Employees must give employer written notice of alleged violation. The Department of Labor will provide a model complaint form, and that's forthcoming. So they've not posted it out there. We have a little bit of time before that piece actually goes into play. But a component of this law is that if employees believe that you've not followed the rules, made a good faith effort to keep the work environment clean and safe, they are going to be able to send you written notice alleging a violation. You will then have some time to respond and fix the issue. So the employees cannot sue until 30 days thereafter unless there is a demonstration for refusal to cure. So you'll have 30 days, within 30 days, to respond to an employee if they are alleging a violation. The plan should include a process to address safety issues on a timely basis, and no action can be taken by an employee if the problem is corrected. An employee also does have 6 months to bring an action to the employer. There is a statute of limitations. So you're going to need to think about a process of where do you want your employees to find the complaint form? Who do they submit the complaint form to? Who is responsible for delivering a response to the employee and resolving the action? Okay, so you're going to need to think about a process for all of the complaint process. The second part of the HERO Act is this component called Labor Management Safety Committee. So effective November 1st, the Safety Committee component becomes an option. The Safety Committee component covers private sector employers with 10 or more employees, and there's no distinction between full or part-time. Private sector employers are required to permit workplace safety committees at each work site if requested by an employee. Means that an employee is allowed to create a workplace safety committee. So just another point on this section here. So if you already have a safety committee, you can utilize that safety committee. You may need to change the mix of who's on the safety committee, because there is a requirement if you do create a safety committee that 2/3 of the safety committee are non-management, non-supervisory employees. And so you just may need to consider who else is on the committee itself. So and the safety committee, if you don't have a safety committee, you are not required to put one in place unless an employee comes forward and asks you to do so. If the employee asks for you to put a workplace safety committee team in place, you need to comply. One of the amendments around this section here was that they at least limited the scope as to what the safety committee would have purview to. So that was very helpful. And the other piece here I'll mention here is, the amendment does, however, clarify that employers are only required to permit one committee per website and do not need to allow another committee where one exists. So if you don't have a committee, an employee hasn't requested one, you don't need to add one. If you have a safety committee and you want to utilize that safety committee for these purposes, then you just may need to take a look at the mix of the resources on the committee itself to make sure that you meet the requirement. If you have a committee at a work site, you're only required to have one committee, regardless of an employee coming forward and asking if they can start their own committee. Some of the other points around the Labor Management Safety Committee. The committee will have enumerated powers, including raising health and safety concerns, reviewing workplace safety policies, and participating in governmental site visits where permitted by law. The committee must be chaired by management and employee representatives. 2/3 of the committee must be non-supervisory employees. Committees must be allowed to meet at least quarterly during work hours, no more than 2 hours. The employer must permit committee members to attend 4 hours of paid training, and the guidance does not say when or how often the committee members can attend. So, committee members can meet on a quarterly basis up to 2 hours. That is paid time. The committee members will be permitted to attend 4 hours of training, and that is paid time. However, there is not enough detail as of what that training allotment is, and so there's more to come that'll get posted on the Department of Labor website in the weeks ahead. For members on this safety committee, as well as for employees who bring forth a claim of violation, employees are protected against retaliation for their participation. Okay, so once we link in to show the prevention standard, I'll show you the document. There is a pretty heavy component here that there's no retaliation permitted for employees who bring forth a violation claim, for employees who want to participate on the safety committee. And so you need to make sure that you understand this and that there's some requirements of where this language needs to appear as you go forward. Some of the frequently asked questions. What if I already have a workplace safety committee? If your organization already has a workplace safety committee, there's no need to create a separate workplace safety committee. Existing plans may need amendments to comply with new law, including any anti-discrimination, anti-retaliation statement. Remember, the need to create the committee is only relevant if an employee asks to create the committee. In addition, if an employee brings up the request, you need to ensure that the committee meets the requirements of the HERO Act. I'm clear on the work plan, but does every employer need a safety committee? No, employees must ask to form a safety committee if one does not exist. A request to form a safety committee cannot be ignored. How do employers decide which rank and file employees will serve on the safety committee? The employer does not decide. The employer does not have input. The employees get to decide who is the 2/3 of the workplace safety committee. And if you have a union, the union decides. You can decide, of course, the management, but 2/3 have to be employees. What if I have multiple work sites? The legislation states that each work site is permitted to have a safety committee. Again, not required, only if requested. Is the plan active at all times or just during emergencies, pandemics? The plan is active at all times, but certain parts of the plan will only be active during emergencies and pandemics, and you'll see that when we get into the work plan itself. What is the minimum number of people in the safety committee? The minimum number is 4. There is no maximum. You can limit the number of people in the safety or on the safety committee as long as you have at least 4 people. And in that 4, 1 can be management, supervisor, and the remaining 3 hourly employees. Who determines when the plan needs to be invoked? The Department of Health or the state by executive order? And does this law apply to COVID-19 pandemic? Only apply to COVID-19 pandemic. No, all infectious diseases now and in the future. What to do and who to call. So as you are developing your work plans, as you are thinking through, what your needs are, you have resources available to help you. Pinnacle HR, we certainly can help you develop or amend a current plan. We can help you customize your model notices, create policies and procedures that need to go in place to support your actions, train your managers on the plan. As mentioned, that is a requirement. Verbally communicate the plan to employees, or form the safety committee itself. So we certainly can help with any of those things. You can work with your HR consultant to identify what your needs are. One of the other things that we are recommending is that you call your insurance agency to review your current limits on your employment personal liability insurance. And the reason for this is because there is a component here where employees can sue their employer if they have failed to respond accordingly to a violation that they have perceived. And so you'll incur costs with having to defend yourself. So we're recommending that you review your current limits and or consider purchasing this type of insurance. It may just help you in the long run. Okay, so I'd like to thank you for joining today's session. And what I'd like to do now is I'm going to share with you a link